My name is Alina Shavtsova. I am an immigration attorney from Brooklyn, New York. In today's live Facebook presentation, I would like to share with you news regarding good moral character, a requirement for naturalization, and what recently changed. Just recently, about a week ago, USCIS updated its manual regarding good moral character requirement necessary for naturalization. Good moral character has been always required for one who applies for naturalization. And the way it worked, that if a person would not have certain criminal convictions, heavy criminal convictions, and would otherwise did not commit fraud, let's say, a person would generally be found eligible for naturalization. But recently I've noticed that USCIS started to use something called Unlawful Acts instead of convictions to find the person ineligible for naturalization. And Unlawful Act is a very broad category. Unlawful Act, again, does not require a formal finding of guilt. Unlawful Act is something that USCIS finds you committed or you've done that precludes you from becoming a citizen. It's a pretty serious change because basically we do not have adequate weapon, adequate means to address this situation. For example, let's say somebody was arrested for possession of a controlled substance and later conviction was dismissed. Technically, a person does not have a conviction on his record, even though he has to disclose the fact of the arrest and what happened. Now, USCIS will still find, most likely nowadays, that you would be precluded from naturalization because of unlawful act of possession. Why is it happening? Well, in my view, it's happening because USCIS is trying to, and the current administration is trying to severely limit the number of people who would qualify for citizenship. But also, I feel that that approach is very unfair. So let's refer to the specific language of the recent changes. Basically, USCIS states that examples of unlawful acts recognized by case law as barring good moral character include. So they put examples that were found by case law as the ones that would preclude you from establishing good moral character. I'm not sure which case law. There is no specific reference here. I'm not sure if it was overruled and things like that. But you have to understand also that pretty much anything negative can be used as an unlawful act, okay? So let's talk about what they said. They're going to now use against you. Bail jumping, bank fraud, conspiracy to distribute a controlled substance. Well, that probably requires a conviction. Failure to claim US citizenship. Do not understand what it is. Falsification of records. Forgery, authoring. So when you state something that's not true. Insurance fraud. Many with insurance for car insurance may need to clear that situation up. Obstruction of justice. Well, sexual assault, social security fraud, unlawful harassment, unlawful registration to vote, unlawful voting, and violation of a U.S. embargo. Violation of a U.S. embargo. That's a very interesting situation. I'm going to tell you from practice what else has been found to be an unlawful act. Failure to register for selective service, even if you explained why you why you didn't register and the statutory period passed. A judgment against you for unpaid taxes, even if you had no idea you had it. So now I think we're entering the stage of our immigration situation when we will have to unfortunately see more and more litigation when a person to establish that his conduct is not an unlawful act, barring him or her from naturalization will have to prove his position or her position in court. Now remember, if there is a denial of naturalization, you can ask for a rehearing. There is a special form for it. It takes 8 to 9 months to get a new interview where a high-ranking officer is going to look into your application and see if the law was applied correctly. But again, unlawful act now is a very broad category that encompasses everything from convictions to allegations basically against you. Now, new statement regulation says that they're going to look into a statutory period, basically 5 years prior to submitting the application, or 3 years or 1 year, depending on the grounds for naturalization. But the law actually says that they can look into any period. It does not have to be 5 years. And I've seen that already happening, where they use something against you that you disclosed in your previous applications that were much earlier than your current application, and that 5 years already passed. What does it mean for you from practical point of view? Well, first of all, you need to know potential problems, right? Any judgments, any lawsuits, any allegations against you that you lied, submitted any forged documents, insurance situation, social security situation, when you disclosed, for example, earlier to someone somehow that you used someone else's social security, or you shared your social security with someone else, things like that. Everything has to be discussed with your attorney prior to submitting the application. Maybe it will be better to wait to submit the application, or perhaps you will have a strong case to argue that you are eligible for naturalization. And you can read more about immigration issues on our website, www.shaltsova.com. Thank you.